and I'll give you, so the link to the live stream is on the notice of hearing. I'm just going to put that on the screen share for now. And you should be able to see that. And it looks like the live stream is running now. So if you could switch over to that, and then I'll just let me know when you're there, and I'll remove you from the Zoom connection, okay? Let some more people in. About Scott Schneider, recognizing the name, but who are you affiliated with?
Judge Newmark, that's one of the Public Service Commission witnesses.
Okay. That's what I thought. Okay, good.
Actually, there are two Schneiders. I think Scott is first.
I'm sorry, Scott's with who?
Your Honor, Scott is our witness, I believe.
Yeah, yeah.
Cub also had a Schneider, which threw me.
Oh, okay, but not appearing today. Not okay, yeah. How about Pete Parker? Are you affiliated with a party, Pete? No. So I just want to check in with the Town of Rock. Just want to make sure if you got the live stream up and running.
Not having very good luck getting into it. And Pete Parker is actually Town of Rock supervisor. I don't know if he doesn't have.
Okay.
Energized
All right. All right. Well, why don't you just hang on the Zoom? I'm just going to mute you, so you just be able to observe, but it's not up.
Okay, that's
Yeah, that'll work. So I don't want you to be able to see it. For people who aren't parties or staff, you should be using the Zoom connection. But if it's not working, then just go ahead and stay on the. I'm sorry, if you can't see the YouTube connection, then just stay on the Zoom. And I just want to mention the Zoom, as far as I can see, why I keep saying that. The live stream is going as far as I can see. So we had some problems yesterday, but it is working today. So just want to triple check here. Yep. It is up and running. Okay. We don't have a lot of parties, so I think we have everyone here that we're expecting. So we can just going to add our attorneys to the. So I added Mike Garcia to the screen. Is Sophia, are you going to be speaking, or should I just let Mike?
No, Mike will do all the work today.
All right. Oh, all the work. Okay. Good luck, Mike.
I think you still want my camera on, right?
It's not necessarily, I guess. Something's going on with my
I'll spare you then.
It's up to you. I mean, I think we'll have, as long as we have one attorney, that's, the primary attorney, that should be fine.
Okay, I'll go off, but I'm still here.
Yeah. Okay. Something just happened to my view here. I don't know what I did. Oh, there we go.
Your Honor,
Yes. Is it Zach?
while we're working on logistics, I just wanted to do a sound check. Are you able to hear us okay?
I hear you fine. Yep.
Okay,
That
great.
should work. Yeah. So I got a new laptop a couple of days ago. It is giving me a few surprises every day. I don't know why it's doing this. Okay, well, I think we're just gonna.
You're brave. When I get a new one, I don't use it.
Well, they take the other one away, so I mean, I have to be able to keep it for a little while. But, I don't know. Okay, well, I think it's where everything's working, so it's just giving me a weird view here. All right, well, let's get started. We'll get on the record. This is docket 6680 CG 171, the application of Wisconsin Power and Light Company for authority to construct a liquefied natural gas facility. My name is Michael Newmark, the administrative law judge for the PSC. We're on Zoom with the utility intervener and commission staff. We're here at the party session where we are taking evidence from the parties and commission staff. And we'll be meeting tomorrow at Blackhawk Tech for a public hearing session. We'll start at 2 p.m. and we'll continue until we've received comments from everyone who's in attendance. And then we'll reconvene at 6 p.m. and do the same for new people with new comments. We're also taking written public comments. That's that opportunity is available by either filing through the commission's website on our public comment webpage or by mailing those comments to us. The details on how to do that are on the notice of hearing. And comments are due, they need to be received by the commission by Monday, March 23rd. So still a bit of time here, but the way you can ensure we get your comment is to use the web link. That definitely will get that in by the end of the day on March 23rd. We're live streaming the hearing if all goes well. We're on YouTube at the link here that's being displayed. It's also on our notice of hearing. And that recording will become an unofficial version of the hearing, a recording for public convenience on the same site. The official version of the hearing and the documentation of the hearing the commissioners will receive will be in the final transcript that we're creating here today. So that's a bit of the preliminary items here. So let's get on. On with appearances. Our service list. So we'll just start in alphabetical order with Citizens Utility Board.
Good morning, Your Honor. Daniel Narvi appearing for Citizens Utility Board.
All right. And Public Service Commission.
Good morning, Your Honor. Michael Garcia, Assistant General Counsel, and with me is Sophia Rogers.
Thanks. And Wisconsin Power and Light.
Good morning, Your Honor. Zach Ramirez appearing along with Taylor Fritsch.
All right. Welcome, everybody. All right. So this case has created a bit of a quandary for me. And I think you've probably noticed on the notice, on the emails that I sent out to parties and staff, the offered evidence list, I had a couple of notes about documents that appear to have been filed in the rebuttal round, but really I think should have properly been filed on direct. I do want to discuss that before we move forward. I know there's not a lot of questions for these witnesses. It should be a fairly simple case, but I'm having some issues with the way that we're proceeding and how we're heading with the rounds of filings and how it's been working.
Your Honor, would you like me to
Not yet.
address?
Hang on. No, actually, let me just, okay, hang on, let's go off the record. So I just admitted Brittany Keys to the Zoom, and I just, Brittany, can you unmute? I just needed to discuss something with you.
Yeah. Hi, Judge Newmark.
Yeah, so are you, so you're not a party to the case, right? Is that?
No,
No,
no.
okay.
Should I not?
Right, if you can use the YouTube link,
Okay.
that's where the public can observe the hearing.
Great. Thanks for clarifying.
Okay, great, thanks. All right, so it's back on the record. Now, I wanted to just discuss this a bit first. And I think I wanted to kind of review just some of the concerns I was seeing and, oh, and we're back on the record, sorry. Some of the concerns I was seeing, I wanted to review, and also, well, my screen is covered up. Oh, here we go. I guess there's just a few questions I had, more of substance. I think they're kind of a legal question. So let me ask this first, and then just to sort of set up my understanding of what the case is about, then we can discuss the issues I have with the testimony. But just had a concern, first of all, just in terms of the way I'm reading the record is that one of the factors for need for the project is service to the Riverside Electric Generation Facility. And I'm curious in terms of the request for Wisconsin Power and Light as a gas customer, as an electric generator, what existing tariff is it, under what existing tariff is it demanding firm gas service to its affiliate, the Wisconsin Power and Light Gas Service? And then what priority of gas service is that firm gas service under its current tariff for priority of service? So that tariff's GR8. And as far as I can tell, Wisconsin Power and Light, in terms of being a large generation customer, it's a transportation customer under GN10. So I guess I'm just not sure when Power and Lights come to the commission saying we need this project to provide firm gas service to a large electric generator, under what right and what service is it actually providing that it currently has authority to provide? That's something that I don't know if the lawyers want to deal with that or if there's a witness that can explain that to me. But as far as I know, there is no firm gas service for large generation existing in the tariff. So in Wisconsin Power and Light's tariff. So that's one thing to address. And the other ones, when we look at the blank rebuttal, portions of Vincent's rebuttal, and I mean, to some extent Christensen, but I think the way, in terms of Christensen referring to Vincent's rebuttal, there's issues in my mind in the sense that we all know in terms of the standards in this case, the issue under 19649 is need for the project. I think it's, the idea of facilities that are reasonable to serve expected needs. And I'm not sure if the need is to serve Riverside, why that wasn't presented in direct. It was mentioned in the application, but it was not fleshed out to that extent. It did not appear in direct and was not fleshed out in the application to that extent. So, and that's mostly with Blank's rebuttal. And then the other critical element in 19649 is cost. But then Vincent introduces this financial benefits offsetting the project costs on rebuttal on pages 4 through 13. That to me is direct. I mean, that's just your main, or not, maybe, it's one of the elements of cost. Not sure why that came in on rebuttal. And then there's also issues with Vincent's firm sales customer additional testimony that came in regarding requests for firm sales. And I looked at the dates of that exhibit. That was known before direct was due. So I'm not sure why that wasn't filed as a supplemental direct with a request for good cause. I'm sorry, it was after direct. So I think there would have been good cause, but it should have been filed as supplemental direct to give us a chance to process that under the proper procedures, so that people could have an opportunity to request more time or to review and see if it's material. But that was just filed on rebuttal. I don't think that was proper. So let's just start with those elements. So I don't know, again, with the tariff issue, I don't know if you need a witness to address that. If that's more of a legal issue, we can go ahead and hear from the attorneys. In terms of the timing of filings, I guess I'll give the attorneys the first crack at that. So why don't you go ahead, if it's Zach or Taylor.
Your Honor, do you want me to take up the tariff item first or the procedural rounds of testimony first?
Let's just stick to my order. So tariff first.
Okay. So for the tariff first, it would be helpful. We have some witnesses that are more well-versed in the tariff than I am. So it'll be helpful to definitely get their input. I would say that WPL approached this with the generators being existing customers, as you indicated under GN10 for a transportation tariff. And so then the idea is that those units are currently receiving one type of service, the transportation, and then are requesting to expand the scope of service they receive. And so then to your point, a tariff filing would accompany any change in service to set the terms for that. And the way that WPL tried to approach that was in filing the testimony of Tim Lyons to indicate that WPL is not yet ready to propose a tariff and what it would entail for that new type of service, but would do that in a rate case if the project were approved.
Okay, but that wouldn't be putting the cart before the horse, huh? Because you're getting approval to build this facility to serve a customer that you don't have yet.
Well, Your Honor, I guess from WPL's perspective, it's an existing customer receiving one type of service. And then if the project were approved, that would be what would enable WPL to provide the additional firm. And at that point, then the recovery of the project, similar to other projects that are not yet in service, they're recovered, in the specificity for how they're recovered is determined in a rate case and not in the construction case. WPL believes that from a legal authority matter, as a natural gas utility, the natural gas utility does have a legal right to provide firm service. It's just then the scope of the service and the charges are what's specified in the tariff.
Okay, so just let me be clear about your argument. Power and Light believes it has the right to provide firm service to large generation customers currently?
Yes, Your Honor.
In what
As a
tariff?
gas utility,
In what
Is it-
tariff
as a-
is that right found?
Your Honor, I guess the legal right wouldn't necessarily be in the tariff. The legal right would be that WPL is a natural gas utility. And in the same manner that it then can seek a specific tariff for transportation for those units, then it would have the parameters for the firm service as well.
Okay. Well, we'll let the greater minds decide if that's correct or not. And then in terms of priorities of service, where does natural gas service to large generation customers currently sit on the list of priorities?
And Your Honor, when you refer to priorities, are you referring to the order in which they're curtailed if there's some type of an event, or is it a different priority that you're referring to?
It's tariff GR8, which would be, yes, the curtailment list.
And then, Your Honor, I would need more time to review GR8. I did not review that before
Okay.
the hearing.
Sure. So
To do later in the
I-
hearing.
that's fine.
Okay.
So just so you know, in my mind, there's no such thing as firm gas to a large electric generation customer, so they're not on the priorities list. And I think that does add to some question about whether, you know, if there is an LNG facility created, what priority is service to a generator versus service to firm customers like residential, agricultural, the higher priorities, higher than transportation right now, which is where large generation is currently served. So that's that priority choice is something that the commission is going to need to weigh in on, as well as allowing WPL to serve large generation under a firm tariff. And then that directly implicates the need of, and size, I suppose, of the LNG facility. So that's why I'm saying, theoretically, is the cart being put before the horse here? And that's an open issue, I think, at this point. So I just wanted to put that out as a preliminary idea for people to be. And if witnesses want to talk about that, I suppose we can address it. I think it's more of a legal issue, but if there's something a witness can add to that discussion, that would be useful. However, the next issue is this kind of presenting testimony sort of out of order. So I don't want to open up a new area where we're doing that. By having witnesses, I think I'm raising this issue so we can pursue it. But I think when it comes to the issues of need and cost, those are obvious, critical, well-known, well-accepted issues that everyone knows about at the beginning of the case. So I would expect to have seen those matters addressed in the application and direct. So let me hear from you, Attorney Ramirez, about that.
So I guess I would have sort of two ways of looking at your question.
Mm-hmm.
One is to try that WPL was not doing its best efforts to comply with the rounds of testimony. And then the second is to talk specifically about the substance of Blank and Vincent, to then relate exactly why those facts came in when they did. So from a procedural standpoint, Your Honor, as you indicated, WPL from the outset was identifying this as a dual purpose facility, meeting the reserve margin for the retail gas customers and then for Riverside, and then identified the need. And then what we identified was responding to several data requests between the filing of our application and our direct. And so then we tailored our direct testimony to work on addressing what appeared to be of interest to both the interveners and staff. And then when we received, since it was staggered direct, when we received the direct testimony from staff, there were several places where then staff's testimony, I believe, reflects staff's role as seeking to have the most information available to commissioners as possible, more than in an advocacy role of trying to close things off. So the way WPL interpreted several statements, which generally were structured in terms of the record would benefit from more information on X, Y, or Z, was a solicitation for more information. So WPL tried to take its earliest convenience to then, or earliest possible time to then provide that information. WPL was not trying to infringe on anyone's rights and would have been happy to entertain any additional time requested, the same way we entertained and agreed to Cub's request for supplemental direct. WPL didn't do that simply because we thought it was in order. And so that's sort of our points on the process and our best efforts. And then on the substance, I would say, Your Honor's point, you raised the big picture issues of the need and the cost. WPL believed it addressed those on direct by identifying the reserve margin shortfall and how Riverside currently does not have its full requirements met through firm contracts. And then from the cost, identified the pipeline alternative as providing, as being more costly than the LNG, so providing the cost savings. And then part of Vincent's testimony on direct was identifying those pipeline curtailments that were experienced. And I would say then, big picture, what we received that triggered the parts that you're asking about for Blank and Vincent on rebuttal was, I would characterize it as staff absorbing what was filed on direct from WPL and taking it a layer deeper. And for example, what I mean by that is Vincent's direct identified pipeline curtailment data back to 1996. And one of the questions was Riverside actually affected by any of that? So we had, on our direct, identified specific pipeline events that had happened, including pipeline that Riverside was on. But then there was the specific question that triggered witness Blank's testimony: was Riverside itself actually affected by any of those? And so then that led into the data. It's worth pointing out that some of the data that witness Blank raised to answer that question, factually, those events did not even occur until after WPL filed its direct due to Winter Storm Fern happening in January of 26, whereas WPL filed its direct testimony December 16th and 17th. So that was what triggered that. The other part about Vincent's was we'd identified the need, and I would say what we heard back, particularly from witness Kirschling, and I could point to specific sections, was, to your point, a sizing question, which was, please explain the tank size and what that additional size would do, and wouldn't there be savings from downsizing it? And so then what Vincent's testimony, where he's providing those savings, identifies is he takes the specific volume of the tank that was in question from witness Kirschling, and he identifies the financial benefits tied to that sizing question. The other one was this issue of the term capacity release, that hopefully we'll stop talking past each other between staff and WPL today more, which was in Kirschling's direct, he asked about, would WPL use a capacity release to avoid excessive costs for customers? And he said the record would benefit more from that. And what Mr. Vincent indicated in his testimony and why that's in there, and what he could clarify more today at the request of staff in a meet and confer, is that essentially a capacity release means one thing to WPL, which is you're relinquishing your rights under a contract and having someone step into your shoes and pay that amount, but then you've foregone your rights under that contract, versus what's sometimes referred to as an arbitrage sale or a commodity sale, is you retain your rights under it, and it's not then technically a capacity release, but you're nonetheless monetizing the benefits of that capacity. And so what Mr. Vincent was doing in that testimony was where witness Kirschling asked for additional detail on whether or not a capacity release would be done, and how then costs of that excess capacity would not be incurred. That was all pursuant to that in our view of the world, Your Honor.
Mm-hmm. Okay. All right. Thank you for that. So I did want to mention, but I'm going to ask for input from everyone else here, but I do want to mention that I've discussed this with this one particular point that you raised, Attorney Ramirez, which is staff inviting what appears to be staff's invitation in direct to add issues or expand the scope of the testimony on rebuttal. And I think we've seen many examples of this where staff is making the statement the record would benefit from more discussion on XYZ. And that occurred several times in this case, but has also been something that I've seen in other cases. And I've advised staff against that. And I think at this point, I'm going to state that in my mind, that is not an invitation to provide additional direct. It's not, I don't believe staff is authorized to, I don't know if this is the intent, but that's regardless of what the intent was. But I don't think that statement has the effect of changing the the contested case process and the rounds of testimony and how that's designed. It's not overruling the FMO in terms of direct being where a party would, party and staff would present the issues in the case and make its case for the commission. Rebuttal is responding to direct. So a statement in direct that says we could have used more information is not an invitation to add that information where it could have been filed in direct. I think it's got, and I think I would like to see, I think we're going to see that be worded differently from staff from now on, where it shouldn't be implied as a invitation to add what should have been filed in direct. It's more of an indication that we don't have what we need and we can't move forward without that information. I don't think staff's role in PSC2 is to, without any, above the process and the procedure that we've set, I don't think staff is authorized to allow or override that process in order to benefit the record. I think staff can ask for more information using its data request powers, and then when it evaluates that information, then seek to offer its analysis on that through the proper motion process. But a simple statement in testimony that it could have used more information is not a means or a mechanism or sort of automatic override of our procedures. So I just want people to understand that going forward. But with that, I wanted to open up comments from Cub and staff. So did you have any opinion on this, Attorney Narvi? Just let you get a first crack at that.
Thank you. Real briefly, Your Honor. Attorney Ramirez and I did confer about this prior to the hearing, and as I told him, Cub does not object to the way that they've done rebuttal. In this case, particularly because it was not rebuttal that was responsive to the specific issues that we raised. And so, it didn't preclude us from an opportunity to put in further testimony. On a more general note, we do think that the rounds of testimony are important, and keeping to the strictures of, responding to the past direct. I do acknowledge the position Attorney Ramirez discussed with staff's testimony seeming to invite further elaboration on issues. And I was going to flag and ask for further direction on how to respond in that issue. So I'm glad that you discussed that, and I think provided that clarity. That we share that concern in a general sense, not, as I said, in this particular instance. We don't have any objection to the testimony, but it does put interveners in a tough position, potentially in some cases if an applicant uses that invitation to put in evidence that interveners didn't have an opportunity to do discovery on, or really to think through, other than the fairly tight timelines that they might have for a SIR rebuttal. So I do appreciate the guidance that you've given on that going forward. So again, with no particular objection to the way that they've done this, especially since the guidance that you've given, Attorney Ramirez and the applicant may not have appreciated before that, but we do appreciate the direction that you've provided here for future cases.
Okay. And staff, any comments?
Yes, Your Honor. First, just to go back to the tariff conversation, I understood that to be more of perhaps an avenue for briefing rather than witness testimony here today. So I just wanted to say that. As far as the current conversation is concerned, I think In this case is a good example of some of the pitfalls of staff sort of gesturing at the need for more information. I think rebuttal had a lot of extra information that staff had less time to analyze. I think your direction is to sort of, in the future, send out data requests from staff, and the response to that would then be supplemental direct to make it more along the process as described in the FMO, rather than all of these new filings at rebuttal. I think that sort of process going forward makes sense. It's going to be something we're going to have to work on, because I think, to your point, it hasn't worked that way always in the past. But I think that framing makes sense.
Okay. Yeah, and and just so we understand, it's not just a procedural issue. It's not just to paper over filing information out of the line of normal course of testimony, but on a request, and if staff were to see a need for more information, file a data request, get that information, analyze it, determine whether it's responsive, and if it's useful, then to file a request for supplemental direct, or I don't know if it may be supplemental rebuttal. I don't, depends on the situation. But the idea would be that gives us an opportunity to take a break, set a new process if necessary, evaluate whether, where we're headed in the case, and to get input from all the participants in terms of whether this information is going to be received or not, is going to respect due process for everyone involved. So it goes deeper than saying, oh, it's going to be a data request instead of a statement in testimony. There is a lot more to it. So it's not a mere a cosmetic change to this process. So with that, I mean, I'm still concerned about the scope of especially Blank's testimony in terms of opening up new issues and new topics that really was not solicited and not responded to, as far as I can tell. So I mean, there's no objections necessarily to this, but I'm just not seeing how it's proper to receive. So if there's any other,
May I add?
go ahead, Zach. Yeah.
Okay. Again, WPL was not trying to infringe on anyone's procedural rights and continues to not have that be its goal, to put in the last word and not provide opportunity. We believe
I'm sorry, to put in the last word and not provide
an opportunity for meaningful review. Your Honor, we were not trying to add I'll give you our lens of the world for this, which was in direct testimony. Matthew Vincent put in data on specific pipeline curtailments that occurred. Force majeures, the weather orders, the limited gas service on the gas pipeline that Riverside is located on. Witness Kirschling analyzed that information, and in our understanding, was trying to understand whether or not Riverside itself actually experienced a derate from the data that we put in on the actual pipelines curtailing service. As a functional matter within the company, Mr. Vincent, as a witness, has information on pipelines. As far as what's called GADS data, which is a computer system at the plant to identify whether the plant was specifically affected by that, that's something that, from a functional area, our generation team has. So from our view, the way we presented it was, to your point, Your Honor, our stated case was because Riverside did not have a 100% firm contract from the pipeline, it needed firm gas. And part of what we identified in Vincent's direct testimony was for those non-firm aspects, there have been incidents on the pipeline that put the operation of the unit at risk. What we understood was, please provide more detail. Did that actually impact the unit? So we did our due diligence, again, trying to respond to the question and pulled the best data available, which is referred to as GADS data, which is in Blank's exhibits. And to your point about not expanding the scope, Your Honor, one was the primary incidents of that we identified there actually occurred after our round of direct because they were in January, but then also there were the ones that were specifically tied to the pipeline events that we filed in direct. So we were just doing our best to answer what we viewed was a follow-up question from what we had filed on direct for Blank.
Okay.
And then to your question of whether anyone used it, Sir Rebuttal Kirschling does use that testimony. He's in his Sir Rebuttal, then synthesizes some of the information that came in under Blank. So there are portions of Sir Rebuttal Kirschling that utilize Rebuttal Blank.
All right. So I'm just checking out the Blank testimony, and I think just to emphasize the issue here, I don't believe that Power and Light was trying to blindside or sandbag people in terms of this process. That was not my implication here, and I agree with what you're saying to that extent, Attorney Ramirez. I think that the issue that I see with Blank's testimony is introducing the evidence on the bulk power system that really, in terms of relying on that as a justification for the and bringing in evidence about the bulk power system in terms of its relationship to this case it should have been indirect. So I think what I'd like to see, what I propose here is to strike Blank the exhibits 1 and 2, and then the lines starting on page 3, 13 through 23, and then page 4, the entire page 4, 5, entire page 5, and then 6 up until between line 1 and 5. And then speaking specifically about Riverside, I think we can leave that in, and I think that also includes Exhibit 3, the data that was presented, the GADS data is discussed there. So I think in terms of the general setup of the bulk power system, that I think needed to be established on direct, and then to talk about some specifics that may relate to Vincent and Kirschling. There's some tie into responding to that information or elaborating on what was used in subsequent testimony. But to be able to I think that when it comes to the need, and generally speaking, that should have been presented earlier. So I would say I can accept the rebuttal with that, with those strike items stricken, simply lines on the page, actually striking the lines, and those won't be received, as well as blank 1 and 2. And then, I mean, the rest, I don't know. I've expressed my dissatisfaction with the process and what we're going to do going forward. So I think I'll just leave the rest of the record as it was filed, with just noting my my critique, but also noting that it wasn't, I'm not accusing Power and Light of any intentional malfeasance here, or sandbagging, or that's not what I'm definitely not been the situation here that I can see. So I'm gonna move on from there. So I'll receive the blank testimony with those items stricken.
Thank you, Your Honor, for trying to come up with a tailored way of balancing your concerns with the record that's been developed at this point.
Okay. And then I did have another couple of preliminary questions just to clear up the record before we get started here. It really focuses in on the load curve filings, and I think I mentioned this in the comments to the offered evidence list, but can probably do this. Well, let me see. So I think it does relate to Hilberry's Exhibit 4, and then let me just say for the record, there's two data request responses. So it's AJK-1.7 attachment A and SAS 4.4 attachment A. And what I was hoping to do is, and then the exhibit Hilberry 4. What I was hoping to do is present to the commission sort of a definitive view of this in an exhibit that is the most complete and up-to-date version of these load curves. And I'm not sure which one. Maybe we have one, or maybe we need to create one that kind of puts things together for the commissioners to review. But something this critical, I think it probably don't want to bury it in a data request response, but we could have it in an exhibit. And I think Power and Light attempted to do that, but I'm not sure if Hilberry 4 is going to give us the complete picture of what we're looking for. So,
Your Honor.
this off the record. Oh, yeah. Is there something you want
Yes,
to
just
record?
yes, on the record.
Okay, yeah, go ahead.
I believe you said AJK 1.7.
Oh,
I believe that should be 7.1.
yes, you're right. Sorry about that. Okay, so we can probably discuss this off the record. And if you need some time, we can also, have you guys look at this while we're doing other things. But let's go off the record and see if there's something we can get on this. My understanding is that I think it was SAS is a different view of this than the AJK response, in terms of the time frames, right? Or the inputs. And I just don't know which one's the best one to try to give to the commissioners sort of as their major view of that. And I think there may be some that Hilberry 4 may not have the latest data, which may be an issue too. So
I want to make sure I understand the question so that we can address
okay.
it. So
Yeah.
is the question whether we're off the record,
Yeah,
correct?
yes, yeah, we're off the
Okay.
But we're on
Is
Zoom and YouTube, so it's
Sure.
yeah.
Yeah.
Okay.
Is the question whether or not Hilberry 4 is the most up-to-date load duration curve in terms of system constraint assumptions, I guess, Your Honor, this gets into, there's sort of two things going on with your goal of having a low duration curve that best captures the situation for the commission.
Mhm.
The load duration curve is a system-wide look. This is something that Witness Hilberry and then Mr. Christensen, who understands the actual physical operation of the pipeline system better, tried to collaborate on, which is that what the commission's practice has been is for the gas supply plan to have that system-wide look. And then the load duration curve was a system-wide look as well. In practice, WPL's pipeline system isn't analogous to the transmission system on the electric grid,
Mhm.
right? It has, so as Mr. Christensen identified, there are certain pipes that only lead one place or the other. So what we tried to encapsulate is when you look at it from a system-wide, you get the load duration curve.
Mhm.
But then the load duration curve is sort of getting to a higher level and not capturing the granularity of where the LNG unit would be needed at certain points in time while there's system capacity. There's particular parts of the pipeline that have a smaller supply. So I
Sure.
guess
Yeah.
I just wanted to set that as there were some things that there's not currently a method for taking the most recent data requests that Mr. Kirschling had and rolling them into a duration curve. The duration curve practice is something that's more attuned to like a system-wide look.
Okay.
And some of Mr. Kirschling's questions about particular pipes on the system
Mhm. Okay.
is a little different from so I just wanted to clarify
Yeah.
if to the extent that that is the nature of your question, if that we put in other system-wide pieces, we can ensure that Hilberry 4 is the most up to date.
Okay. I guess the first question was simply, is Hilberry 4 as it appears now, um, does it have the most accurate and up-to-date inputs? Because I thought there maybe were some new numbers that were filed in a data request. I thought
And you were indicating that was AJK, that there was more recent in an AJK data request
I
response?
think AJK 7.1 is more recent. Yeah. Mhm.
Okay, we can follow up on that one, Your Honor. And
Okay. And then the other one, the other issue is, so Hilberry 4 is the load curve for the system wide. That's correct?
yes, that's
Okay. So then in terms of the other curves that we see, so there's another table in the data request that speaks more directly to the service that would be provided by the facility, I think. Is that maybe I'm confused about this, so that could be the problem. But so there was another curve in the record, and I thought it would be useful to maybe have those in the same exhibit. So I was proposing originally Hilberry 17, which I described as, oh, okay. So it's in Hilberry's rebuttal, talks about cites a number of data request responses, and maybe it's just enough to have them just all put into one exhibit, and that's what I was calling
okay.
Hilberry 17. But I just want to make sure that's actually gonna help us. So it was page 20.
And for just a little bit of clarity, the data
Mhm.
request AJK 7.1 was after Hilberry 4. So that's
Right. And that's part of so Hilberry's citing on page 20 the SAS 4.4 attachment A and AJK 7.1 attachment A. And then there's also the exhibit 4, Hilberry 4. So, I mean, just to give the commissioners an easy way of looking at all of this, would it make sense just to put those all in one exhibit? Or
And
or
particularly
we,
referring to
yeah.
footnote 36, just to make sure I,
Yes, footnote
okay.
30. Yeah.
And then we would do that as a post-hearing exhibit.
Yeah, if that's going to be, if that would, cause the result we're looking for, I think maybe we want to just make sure we're going to, that's true, and we're going to get what we need from that. And that would be, I already have it marked as Hillberry 17. So it would be a post-hearing exhibit, but it's simply one that we have identified at the hearing and received at the hearing, with the understanding of what, we know what it is, and you can just file it without any kind of, motion process.
And just for clarity, that's you just want the 2 data request versions of the low duration curve. So SAS 4.4, AJK 7.1, because exhibit Hillberry 4 is already in the record as Hillberry 4.
Yeah, I mean I suppose. I mean, it'd be nice. It might be useful just to have them all in one document so that the commission isn't kind of rifling through the record trying to find it. So that's and Hillberry 4 is a response to a data request as well, isn't it? I think that information is in a. So I would say put them all together in 17 so that it's just easier to reference. But I guess I just make sure that we're getting what we want and that it's all everything's up to date in the current tables, because I just recall that maybe something had been updated between SAS and AJK.
We'll take a look at the versioning.
Okay, great, thanks. All right, so we're off the record. I did want to check in. We had a couple other people join us on Zoom. I just want to make sure you're connected with a party. So it's this person has a screen name of THELEJ. So I'm going to ask you to unmute, and I just want to know if you are connected with the utility or a party.
Jeff Thielen with PSC.
Okay, great, thanks. I would never have gotten that from there. Okay. All right, so I'm just gonna mute you, and you can stay on here. And then we have Carla, who's in the waiting room. Let me check. I don't know. People are coming in still. So Carla, I see you joined us with Power and Lights LNG party hearing session. I'm gonna unmute you. Are you connected? And just wanted to ask you if you are connected with the party or commission staff. Yeah, go ahead. You're having some trouble here, I see. Carla, can you answer? Yeah, you're unmuted now. So I'm going to invite you to, if you're not, well, either way, we are live streaming this on YouTube. So I'm going to ask you to just switch over to that connection. This is for parties and staff. And there's so you can see that on the screen share. That's the location of the live stream. All right, thanks. All right, so I think we're good to go. Sorry about all the preliminaries, but I think we need to address that first. That's why they're preliminaries. So let's continue with items we usually do at the beginning of the hearing. First of all, now that
On the record?
yes, let's do this on the record. Thanks.
Okay.
So a few things we want to discuss before we take our first witness. First of all, we've made a few adjustments to the documents here, but let me ask applicant, are there any errors or omissions to the current offered evidence list?
Not that we had identified.
Okay. And Cub?
No, none from Cub.
None from Cub, okay. And commission staff?
Your Honor, I do have one clarification on your comment for ex-PSC Schneider.
Okay, let's just take errors or omissions first, and then we'll
Oh.
go back with comments.
Sorry, Your Honor.
That's
No,
okay.
no. Nothing.
Okay. So go back to the applicant. Any issues with the comments? Any questions, concerns?
Did we
yeah.
resolve, the confirmation would be, did we resolve all comments? Are there any other filings pending admission?
Well, I did have some questions with, and I'm sorry, now I'm looking at this. This is why I have these comments here. I did have some questions about the Lions exhibits 2 through 4. And I see that Lions is citing testimony of other people in other proceedings in other states, which kind of runs us pretty far afield in terms of what we usually will accept as sort of what documents we're going to rely on. But also, it doesn't, these are very extensive documents, hundreds of pages of testimony, which is interesting to know that the testimony, what they look like in other states. But I think I don't know if, to the extent the witness has knowledge and can make those statements without referencing or offering for the record those documents, I don't think the record really requires that much extraneous testimony. If this is something the witness reviewed and then came to the witness's own conclusion on, I would be happy to accept the testimony with the not record evidence disclaimer to the citation to those. But to have them introduced as evidence when we don't have the case in front of us in these other states, we don't have the rules of these other states in front of us, and we don't have the witnesses, I think that stretches our kind of allowance for bringing in these kinds of documents into the record when they possibly isn't really that necessary either, since we do have an expert making the expert's conclusions. So any comment on that from the applicant?
Yes, Your Honor. Looking at direct Lions 7, can you still hear me okay?
I can see you. I'm still having some issues here with this. Oh, here we go. Screen. I can put it up on the screen here.
Okay.
Yeah. So you were saying page 7?
Yes. So if you scroll to 7, it's just an illustration of what the purpose was, which was simply, here we go.
Yeah, sorry, I can't really read it on my screen. I don't know, you're not gonna be able to
I'll
see
just
it.
give it a moment to download.
Yeah, let's go off the record. I don't I have a feeling that's not gonna do it. There we go. Okay, to restart it. Okay, excellent. There we go. Page 7, we got it.
So on that
Back on the
line-
record?
Yes.
Okay.
Yeah, thanks.
So on line 13,
Mm-hmm.
You have the simple statement. For example, Minnesota's Northern States Power uses design day demands to allocate its LNG facility costs.
Mm-hmm.
And then to your point, footnote 5 goes to exhibit lines 4, which is the full cost of service study.
Mm-hmm.
And WPL then, as you see from Lyon's testimony, is not doing or attempting to enter into the record more information from or utilizing that full cost of service study. It was simply to try and satisfy what our understanding for the facilitating matters order was, that since Mr. Lyons is making the statement that Northern States Power Minnesota uses design day demand allocators to then identify the source of that.
Mm-hmm.
And then, as you're familiar with, oftentimes these types of things you don't get like the Minnesota Utility Commission in black and white words in the order itself saying, we're going to use this, right? It lives in the cost of service study. So
Sure.
that was our best way to do it. We're definitely open to having it be a not record evidence because as long as you're allowing the actual conclusions or summaries to remain in the testimony.
Yeah, I mean, this is a good example for using the NRE disclaimer. I think that's just perfectly valid. So I would, if that's a similar situation with exhibits 2 and 3, then I would just refile using the NRE disclaimer, and we'll just strike those exhibits. So you'd want to strike references to those exhibits as well as adding the disclaimer.
And then no substantive striking happening to the text of the testimony, right?
No, I think that's fine. The witnesses read the document and made a conclusion, and and the document's being provided for other people to review if they want to. But yeah, I don't think we need, and I don't think it's appropriate to include the entire document in the record, and it's really not pertinent. So let's
We can
take care of
refile
it.
as NRE then.
Great. So just note this. Okay. So let's get on the record. So we discussed the introduction of WPL Lions exhibits 2 through 4. And we've reached a conclusion that striking those will make the most sense. So we'll strike those exhibits and the references to the exhibit mark in direct WPL Lions. And then in terms of the citations to those exhibits, they should have the added NRE disclaimer to those citations. So I think with that, so that's a comment. So I think that's all so let me just ask, any other questions on the comments from the applicant?
No, Your Honor.
All right, and for Cub?
No questions, thanks.
And yeah, so now let's get the commission staff. Any comment, questions?
Yes, Your Honor. Just 3 quick ones. For your comment on direct Adam 6, footnote 4, the intention was not to incorporate that prior testimony. Would you prefer we just remove the direct citation to that?
That would work very well. Yeah.
Okay.
That's fine.
Thank you. And I did miss the data request response exhibit. There is a revision to that
okay.
is coming through.
Oh, it's pending. Okay.
It's pending, correct.
Okay, and you had one more?
Yeah, and the last one is for ex-PSC Schneider. Your comment there is that it should be 1R2 on the very bottom.
Yes.
I think the error is that the bottom of the cover sheet, if you want to pull that up.
Yep. Slowly, yes.
I think the error is that it's R-1 as opposed to Schneider-1R.
Yes.
So just clarifying what the actual issue is, and that will get fixed.
Okay. Yeah, just use the testimony format instead of the exhibit format for the R.
Correct.
Yeah. Okay, that's it.
That
All right,
is-
and And let's just, I think, so I don't know, Attorney Garcia, I think there were some issues with pending confidentiality requests. Did you want to address that or flag that for us? Or I'm not sure where we're at with those. So, and we probably should go on the record for this, if
We
that's,
are on the record.
oh, we are. Okay, good. You're being so still. It was hard to tell. Okay. Yeah. So if you want to proceed with that, go ahead.
Sure. There was a conversation about some confidentiality requests in rebuttal WPL blank, rebuttal WPL Christensen, and exhibit WPL Christensen. I don't know how detailed you want us to get on that. We just are in a back and forth on the applicant about
Okay.
getting those entered properly. I sent them an email on it. We're having a discussion about it.
Okay. As long as we all know that there's something pending there. And because I suppose if I'm accepting the documents, I will also caveat that with those may change in light of any staff confidentiality determination, the redactions versus the public. I'm sorry, the public redactions versus what's confidential may appear differently in the final versions that we accept.
That works for me, Your Honor. It's
Okay.
relatively minor. I think it should
Okay.
be cleared up today, but
All right. And then we'll just treat them confidential. The confidentiality, we'll treat them as they are filed currently. So if we need to go into closed, even though maybe staff may dispute a certain item, we'll handle it confidentially at this point because you haven't made a final determination on that. So with that, I think I'm going to accept the documents pending verification and correction. So all the documents listed on the offered evidence list will be received with those caveats. So I think it's time we can take witnesses, or we could maybe break for 10 just to regroup here. So let's get back. We'll take a recess for 10 minutes. Let's get back around. Let's make it just an even 11:25. Give you some time to regroup here, and yeah, and I'll stop talking so you can get your break. So we'll be back 11:25.
Thank you.
Right, I have 11:25. So let's get back on. So I apologize. I forgot to ask if we can excuse witnesses before we did that break. So sorry if you're waiting for that, but so let's just go through the list. I know there's not a lot across, but there may be some additional statements from witnesses. So let's start with the applicant. If there's any witnesses that we expect to excuse, or are you going to call them all?
Your Honor, we have the witnesses available. If there are no cross-examination questions, then in the interest of time, then we would request to excuse and have written affidavit from witnesses. At the request of staff, we do have some additional direct planned from witnesses Curtis and Vincent. If there are no questions for the other witnesses, other than Curtis and Vincent, then we would request to have them filed by a written affidavit.
All right. So let me ask Cub, Attorney Narvi, any questions for the witnesses other than Curtis and Vincent?
No.
All right. And for commission staff, same question?
No, Your Honor.
All right. Okay, yeah, so let's excuse. Let's go through the list here. We have Blank, Christensen, Hillberry, Lyons, and Schaefer. So they can all file by affidavit. And I guess we'll just need to verify if the attorneys can let us know if we're good to go with Hillberry 17 by the end of the day. And then for Cub, any questions for witness Adams with Cub?
We would just like to verify his testimony on the record today.
Okay, that's fine. Should ask that first, you're right. And commission staff will all be appearing, I'm guessing. Yeah.
That's correct, Your Honor.
Okay, all right. So let's proceed then. Applicant can call its first witness.
Apologies, Your Honor. My computer switched off during breaks. Give me just 1 second.
All right, off the record. No apologies necessary, given what I put you all through today so far.
Was that Mr. Frisch?
Yes, yeah.
Thank you.
That was, and we'll also get Mr. Curtis down here.
I'll go get it.
Mm-hmm. Okay.
Yeah.
I can probably. And what's witness Curtis's first name?
WPL calls Eric Curtis.
Eric, thanks.
Good morning, Mr. Curtis.
Oh, wait, first I got to swear him in. Just a second.
Oh, sorry.
That's
Got ahead of
fine.
myself.
Just adjusting a name here. Okay. All right. So I see you there, witness Curtis. I'm going to swear you in. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth?
Yes.
All right, go ahead. Take it away, Attorney Frisch.
Good morning, Mr. Curtis. Are you the same Eric Curtis that caused to be filed in this case direct and rebuttal testimony and 4 exhibits, including the application exhibit?
Yes.
And did WPL cause to be filed in this case a correction to your direct testimony identified as request of WPL to correct direct WPL Curtis?
Yes, that is my understanding.
Do you have any further corrections to make to your direct or rebuttal testimony at this time?
Yes, I do need to make one additional correction to my rebuttal testimony. On page 11 of my rebuttal testimony, I think this is Christensen.
Oh, yeah, you're right. And we're so while we're doing that, you're dealing with the public version, corrections to the public?
Correct.
Okay. 11. Okay.
Yeah, so if you could scroll up just a bit, lines. Yep, right here. I state that WPL evaluated more than 20 sites, identifying 13 sites that merited further consideration. Just want to clarify that WPL did in fact, evaluate more than 20 sites on the onset, and wanted to clarify that there were 6 sites within those more than 20 sites that were evaluated for single containment tanks. Just wanted to note that, we did evaluate those first, and WPL was not able to acquire those initial 6. And it was at that time that WPL pivoted to a full containment tank design, which that is what is referenced as the 13 sites, as there were 13 sites evaluated for full containment tanks.
Okay, I see.
Thank you. I'll have some brief oral questions for you with respect to the facility siting we were just talking about. But with those corrections, are your direct testimony consisting of 25 pages, your rebuttal testimony consisting of 15 pages, and sponsored exhibits true and accurate to the best of your knowledge?
Yes.
And if I asked you the questions in your testimony live here today, would you give the same answers with the corrections that we've discussed?
Yes.
Have you reviewed the surrebuttal testimony of Commission staff witness Alex Kirschling?
Yes.
As related to project citing, what additional information does witness Kirschling request from the applicant WPL?
Yeah, on page 2 of Kirschling's request, he requested additional discussion on the specific sites evaluated by WPL.
And do you have additional information that you could share regarding the specific sites that were evaluated?
Yes, I have prepared exhibit WPL Curtis 4, which is a map showing the confidential locations of sites that WPL evaluated, and in some cases actually negotiated with landowners to acquire land for the project.
So at this time, Your Honor, I'd ask you move into confidential session to look at proposed exhibit WPL Curtis 4, the confidential version.
Okay. Yeah, before we go ahead with that, I was just curious if we can get input from commission staff as to whether this is really what the request was seeking, and perhaps there be less of an offer that would satisfy staff's interest here. So
Your Honor,
Yeah.
this is staff.
yes.
I'm not sure that we need to see the map. I've had a meet and confer with the applicant's attorneys, and the discussion we had, I think we could do without the map if they could just explain why they chose the sites or did not choose some of the sites they determined that they didn't need to use. I think that would be sufficient. And I think the applicant can correct me if I'm wrong, but I think all of that can be open and public, so we wouldn't need to go into a confidential session.
Okay. So just to be more specific, then what is staff seeking in terms of information regarding the evaluation of the location of the facility?
Staff was seeking to just understand why those 13 sites may or may not have been considered suitable for a containment tank. The response we got in rebuttal just didn't say much more other than the sites weren't able to accommodate. And it's my understanding that the applicant's witness is going to have an explanation for why they decided not to use some or all of those sites. That's really all staff was seeking. I don't know that the additional filing really adds to that.
Okay. All right. Well, any response then from, I mean, we can hear from Cub and the applicant, of course, the applicant, but Cub, feel free to chime in here as well.
Cub doesn't have any concerns either way.
Okay.
Yeah, I think we can address the question that staff counsel raised without looking at the specific exhibit. I think our intention in offering it was, in the event that there were specific questions or more specific information sought, we wanted to have it available for use at the hearing. I don't think WPL believes it needs to be in the record today. So I'll ask the witness a few more questions designed to elucidate what I think staff are interested in. And then assuming that I think meets their needs, or staff counsel can ask questions in cross, designed to ensure that we meet it. I don't think we need to specifically look at the exhibit.
Okay, let's take it from there and see where we go. Thanks.
So, Mr. Curtis, you testified this morning that WPL identified 6 sites over the course of the siting process that could have accommodated a single containment tank design. Without identifying those sites specifically, did WPL consider acquiring those sites?
Yes,
Did you say acquiring those sites, counsel?
Yes.
This is, okay, thank you. Go ahead, sir, I'm sorry.
Yes, we did. We did consider acquisition of all 6 sites for various reasons. You know, a few of them did not qualify as suitable for it, and then we also were not for the other 4 that I'm talking about. WPL, was not able to come to terms with the landowners. Some had multiple landowners to get the required contiguous acreage, and we were not able to come to terms with those landowners. Various different reasons.
And then with respect to the 13 sites that you indicated were evaluated for full containment, for a full containment tank design, why wasn't WPL able to cite a single containment tank at those locations?
Can you say that again?
Yes. For the 13 sites that WPL evaluated for what you refer to as full containment sites, why wouldn't those sites accommodate a single containment tank design?
Oh, the vapor dispersion and heat radiation zones, right? Certainly much larger on a single containment tank design. That is certainly one of the benefits of a full containment tank design. It does allow you to site the project on a much smaller parcel. Pretty significant reduction in required acreage to do so.
And so your testimony, just for clarity, is that none of those 13 sites had sufficient contiguous acreage to allow for that single containment design?
Correct.
Can you just generally describe the process of how WPL identified and screened potential sites for this project?
Certainly. As noted in my testimony, WPL determined a number of reasons why the Janesville-Beloit region would maximize our customers' benefits. We also knew that there was benefit to siting near one of our largest generation locations as well at the Riverside Energy Center. The other main siting criteria, we did want to be close to the WPL gas utility high pressure gas line. Reason for that is high pressure gas is required for gas to liquefy, as well as vaporize gas back out into the system for use. Another siting criteria was we wanted to be near a transmission level service, right? So demand from a liquefaction standpoint is quite high. So we wanted to be near transmission level transmission service versus a distribution voltage. So those were some of the main 2 criteria. Environmental items were taken into consideration during the site evaluation as well.
I want to direct your attention now to the document that has been marked as proposed XWPL Curtis 5. We could pull up Curtis 5.
So, so I guess I'm just curious if when the same same concerns that we were raising with staff before on Exhibit 4, if that doesn't apply as well, or if there's something added to gain from this exhibit before we.
Yes, if I may, Your Honor,
Mhm.
the applicant's understanding is that staff have requested that these actually 5 and 6 both be offered for the record. And so I'm just laying brief foundation for me to move those in orally today.
Okay, that's fine. Just wanted to check in that. Let me find my screen share button. I'll be right with you. Oops. Okay, so I have here on the screen what we're going to mark Curtis 5, Exhibit Curtis 5. So go ahead.
Mr. Curtis, do you recognize this document?
Yes, this is the dispersion. I'm sorry. Yes, this is the revised intermediate siting report prepared by Jensen Hughes for WPL's owner's engineer, HDR Engineering.
And in general, what does this revision address?
In general, it includes additional modeling requested by commission staff.
Okay, I now want to direct your attention to the document that has been marked as proposed XWPL Curtis 6. If we could get Curtis 6 pulled up, that would be helpful.
Yeah. This is Curtis 6.
And do you recognize this document?
Yes, it is the dispersion explosion attachment that supports the previous exhibit, the revised intermediate siting report, also prepared by Jensen Hughes.
And is it your understanding that commission staff also desire to utilize this attachment as part of their analysis?
Yes.
Of the project?
I'm sorry, I didn't
with
hear an
that-
answer.
Yes.
Thank you.
With that, at this time, I'd move XWPL Curtis 5 and XWPL Curtis 6 into the record.
Okay, are there any objections?
None from staff, Your Honor.
Okay. I did want to seek some additional information before we admit the document. At what point was the Power and Light aware of staff's desire to obtain this information? Around what date?
I believe it was in the last week to 10 days.
It was, okay. And then in terms of the date of these documents, looks like we have for Curtis 5 revision number 2. It's labeled revision number 2 and it's dated March 16th. And it looks like the Curtis 6 is dated March 17th at 5:52. So that's interesting. Okay. Hang on, let's just go off the record for a second. Did we actually receive that before that time? Was it PM or AM? PM.
I believe. Oh, that's a fair question. I think we received it before then.
That's interesting. Okay. Well,
Sure.
yeah. Oh, that's I think we did. So, okay. So, I guess I just curious about. Well, I suppose you were not aware that staff was seeking this. We're off or on? Yeah, let's get on.
Okay.
Yeah, sorry. So it seemed to me that we were what you're stating is that the company was not aware of staff's desire to receive this document until about a week ago, and that there was a revision made to Exhibit 4. I'm sorry, Exhibit 5, March 16th, And then Exhibit 6 seems to be been created on March 17th. But what was needed to be revised for those in this document? And it looks like the revisions were made very recently. So if you could just describe what revisions were made and why they were done so close to the date of the hearing and the date when the document was provided to staff.
Yeah, there were two questions from staff. One that revolved around the asphyxiation level, so that was corrected in the intermediate sighting report. I'm trying to remember the second request. Oh, the dispersion along with that, which is the second exhibit here.
So that same information changed the dispersion report, or
It's the actual input data for the result.
okay. So that was just conducted the day before yesterday and yesterday?
Correct. Yeah, the modeling was done and received just earlier this week.
Okay. And would it be safe to say that what's displayed in Curtis 6, the consequent summary report, that's the inputs to
It's supporting data for the intermediate sighting report.
Okay, so first the report's created and then the summary. First the report is created in Exhibit 5 and then the results are reported out in Exhibit 6.
Correct.
Okay. All right. Well, there's no objections. I can receive these documents. Yeah, I'm not really sure how that all transpired, but we'll just let it in at this point. All right. Well, continue, Attorney Frisch, if you need to.
Yeah, just one minor clarifying question.
Sure.
With respect to Exhibit 6, did WPL verify that Jensen Hughes, the timestamp on that document is completely accurate, or what time zone that is in?
No, that's the data is somewhat confusing.
I'm sorry. Did you hear that, Debbie?
The data is somewhat confusing.
Okay.
That's what I said. Yeah.
Well, is it the data is confusing or the date is confusing?
The date, the timestamp.
And to the best of your knowledge, Mr. Curtis, when did WPL receive that supporting attachment that's now labeled as Curtis Exhibit 6?
On Monday, I believe, the 16th.
Okay. I have no further questions, and the witness is available for cross.
All right. Okay, so any cross? We'll start with Cub
No cross from Cub.
and commission staff.
Commission staff does have one question, Your Honor.
Okay.
Your Honor, would you be able to pull up rebuttal WPL Curtis 14?
Yes, I think I have it here on the public version. Yeah, am I in the right place?
Yes, Your Honor.
Okay.
Good morning, witness Curtis. I'm Michael Garcia, representing commission staff. I had one brief question for you on your rebuttal testimony. If you see there at rebuttal Curtis 14, you are discussing commission staff witness Schneider's proposed order condition requiring WPL to submit required information to demonstrate design compliance. Do you see that there?
Yes.
I believe with the addition of the information given today, that order condition may not be necessary, but staff has not had the time to fully analyze it. Would you object to that order condition being included with the understanding that it may be fulfilled by the documentation filed in exhibits Curtis 5 and 6?
No objection to that.
Thank you. That is all I have, Your Honor.
All right, thanks. So, while we have this on the screen, I did want to point out, I think I'd seen this before, but that comment got lost in the shuffle. So staff has an interesting way of naming its data requests, but so that the one that appears on the screen here at line 11 is data request PSC Young, and then it gives a number 6. The FMO actually wants to, directs participants to cite to things a little differently, which is to actually use the initials of the person who is requesting making the request itself, the question, drafting the question. I'm not sure who that is in this case, but I think the company understands this, has done this in the past, but just so you know, for everyone, we'll want to see, that should be, you should use the FMO directions to cite to the exhibit for the data request. But I'm not sure if I even mentioned that in the offered evidence list or not. But I mean, if I didn't indicate that, I guess, I mean, I don't think there's any.
If I may just briefly, Your Honor, you did include that.
I'm sorry, who's speaking? Who
That
just
was
said,
Kurt.
if I may briefly, Your Honor?
That was Attorney Fritsch.
Okay, I'm sorry, your box didn't light up. If I may, go ahead.
If I may, Your Honor, I just want to clarify. It was included in the offered evidence list, the comment, and we will make that correction. I thought we caught them all, and we just missed this one.
No, that's fine. Sorry about that. I just didn't remember. Okay, so let's just go off the record for a second. I just had a question for Attorney Garcia. My understanding is that staff was looking for information whether the sites met the federal the CFR requirements, the federal pipeline safety requirements in terms of location. Did we get an answer to that, or is that included in the documents, perhaps?
Staff believes that's included in the documents we just got. They just haven't had time to fully analyze it. So that's why I wanted to make sure that order condition could still be put in.
Okay, I just want to make sure I understood that we're communicating the same things. Okay, thanks. All right, so so there's no cross for the witness, and the witness is excused then. Thanks.
WPL next calls witness Matthew Vincent. Take him a moment to come to the room.
Sure, let's go off the record. Well, let's get on the record while we're waiting. Looks like I did have a couple of comments on the Vincent exhibits that we forgot to address here. It was 9, 10, and 11 and 13. And I think the questions were really to the extent of what we were it's sort of similar to the Curtis exhibits. What this is needed for, is this a necessary inclusion for the evidentiary record. These are, I think, for proceeding transcripts. Exhibit 9 is Exhibit 10. Just get those up here. Yeah, the FERC. So Northern Natural Gas Company's FERC tariff. And then 11 is this A&R Pipelines FERC tariff. And then 13, I think the question was simply whether that was a excerpt of a bigger document, and then, you know, the typical practice is to at least have like the title page or some sort of cover page included as well, if that's the case. So while we get through the witnesses, once we have the witness seated and checked in, we can discuss that to the extent we need the witness's input. He's available, so that's good. So let's swear you in. I'm going to have you raise your right hand, sir, and do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
All right, so let's check in the witness. Go ahead.
Your Honor, do you want me to address your record questions first, or first do the witness testimony? I believe I can speak to your comments.
Sure. Why don't we can address the comments first. That's fine.
Okay. So, yes, for your
I'm sorry,
first-
it's hard to tell. Is it still Mr. Ramirez speaking?
Yes, it is.
Thank you.
So your first question, I believe, was on Exhibit 13 for Vincent. Was that part of a broader document?
Right, that's correct.
And I believe the answer is no, that this is the entire document.
Okay.
And so I could have that confirmed with the witness. Mr. Vincent, to your knowledge, is what I'm showing as Exhibit Vincent 13 the entirety of that document?
Yes. It was sent via email.
Okay, so is it an attachment to an email?
Or it may have even been in the body.
And then,
Okay,
Your
so
Honor,
it
with
is, so then it would be part of a bigger document, but okay, that's fine. All right. Yeah, go ahead.
and then with regard to Exhibit 9,
Yep.
would it be appropriate to have that be transitioned to not record evidence citation? Mr. Vincent's testimony uses some quotations from that document to demonstrate, substantiate the concerns that he was raising about WPL specifically. And then the document was provided just as a support for those excerpts.
Yes, so just to add the NRE, so we'll do the same thing as with Curtis. We'll strike the exhibit mark and add the NRE disclaimer to looks like footnote 12.
And then for Exhibit 10, that is the Northern Natural Gas Company tariff. And Mr. Vincent's testimony describes some of the operational limitations that he manages. And he also then summarizes the data regarding pipeline events and then provides the tariff to show the source for some of that. WPL again would be open to have this be converted to NRE as the substance lives in the testimony, and the tariff is provided to substantiate the statements made in the testimony.
Okay, I would agree with that. And I'm having trouble finding that citation, but it would be the same process as with Exhibit 9.
And then I believe the same applies to the Exhibit 11, which was the A&R Pipeline Company tariff. Again, Mr. Vincent describes what is commonly known in the industry in his testimony, but isn't necessarily common knowledge to individuals not working. and the industry uses some of the terms of art. And so then the tariff was provided to provide more reference for those who are attempting to understand the content.
Mm-hmm.
And then I believe the last one that you asked about was 12. And then 12 does have more of the specific, I would say, quantitative data, where some of the concerns that Mr. Vincent described then relies on the analysis that was performed by NERC, the North America Electric Reliability Corporation, where that entity is actually the one that had the suitable data to identify the results and impacts on customers of Winter Storm Elliott. And so WPL would like to continue to have Exhibit Vincent 12 be record evidence.
Mm-hmm. Yeah, that's actually not one that I picked out. So I think
Okay.
that's okay.
I was rolling and I went too far.
That's okay. I didn't want to interrupt you, but yeah, no, I think
Okay.
we'll leave 12. And maybe I just missed it, but I didn't catch it, so we'll leave it.
Were there any others you had?
Let me check. I don't think so. No, I think we caught them all. Yeah.
Okay.
All right. So then, thank you for that. So for exhibits Vincent 9, 10, and 11, we'll strike that, and we'll strike that those exhibits. We'll strike the references in the testimony, and add in addition, we'll add the NRE disclaimers to the citations to those documents in the testimony. All right, thanks for clearing that up. Sorry, I missed that at the beginning. So I'll go ahead with whatever else you have for the witness.
Yes, yeah, based on some comments in staff's rebuttal and some meet and confer, I have some limited direct for Mr. Vincent that's immediately responsive to the most recent round of rebuttal from staff.
Okay, go ahead.
And then, Your Honor, I'll be referring to Kirschling, rebuttal Kirschling 4, if it's helpful for the participants to have that up.
Sure, thanks for that.
Mr. Vincent, rebuttal Kirschling 4, lines 9 and 10, which are shown on the screen. Witness Kirschling states that it's not clear whether Riverside's contracts were included in the list of WPL's capacity contracts that were provided in Exhibit PSC Data Request Response AJK 710. Is it your understanding that Riverside's contracts were included on page 1 of attachment B, indicated with primary delivery points listed as Tiffany East and Whisk Power Group 2?
That's correct. Are we
That's
gonna look at it?
That's this.
Okay.
Not unless another party does. It was just to clarify where they're located to resolve that question. And then, Your Honor, similarly on rebuttal PSC Kirschling 4, another question. Mr. Vincent, on this section of staff's rebuttal, Mr. Kirschling states that it's unclear to what extent Riverside's current non-firm or interruptible contracts contributed to its service being compromised in January of 26. Is it your understanding that the service compromise was a result of not being able to obtain service through the non-firm and interruptible contracts?
Yes, that's correct. To take it a step further, what's they believe defined as firm secondary would fall into the same category as interruptible and non-firm, especially during a winter event such as Fern.
And Mr. Vincent, is it WPL's practice in circumstances such as this to get service to Riverside using firm secondary to the extent it's available?
Yes, we'll pull out all the stops to do what we can to get as much gas to the facility as possible to make sure that we can continue to generate and meet the needs that are called on by the day ahead or real time awards from myself for the generation facility.
And then, Your Honor, my next direct will be in response to page 2 of the testimony you have on the screen. Rebuttal Kirschling 2.
Okay.
Mr. Vincent, is WPL open to doing a capacity release in a future year, depending on the market circumstances?
Absolutely. The capacity release, to the extent that it's plausible or feasible at the time, would be considered and would be pursued if the market conditions, supply demand balances, what some of the unique variables may be at that time. I believe that to use it at this point could be premature, given that we don't know with certainty that it is something that we could rely on as being there. It would really depend on the time or what's happening at the time that the decision would be made. Further, the belief is, my understanding, or the way that my opinion is on this, is that the capacity release is part and parcel to the same type of capacity commitments that are discussed in the gas supply plan. It's the annual gas supply plan that WPL would file, and is similar to capacity commitments, given that they all would impact the outcome of what that calculated reserve margin.
Mr. Vincent, could you please discuss the similarities and differences between a capacity release and a natural gas commodity arbitrage sale?
Sure. They're not mutually exclusive. They are two different transactions, and that I guess the similarity would be that they are both potential vehicles to manage or mitigate customer costs. I would say that the capacity release, while you're providing another counterparty with the rights under that contract, they assume all of those rights and responsibilities, including the financial responsibility of the cost of that contract. So in that case, it's a way for WPL to avoid paying capacity that would ultimately flow through to customers through the PGAC.
I'm sorry, through the,
PGA,
was there a word after that?
the purchase
State?
gas adjustment clause. Purchase gas adjustment clause, I believe, is the definition, and it's Wisconsin.
So off the record, I think a C, PGAC is
Okay.
the letter you missed. Yeah.
Thank you.
And Mr. Vincent, in a future
One
year,
moment. We didn't say back on the record, Your Honor, just
Oh,
making
thank
sure.
yeah, I think we're back. Yeah.
I've been writing.
Okay. No, it's
Thank
good.
you, though.
Good to check. Good to check. You're right. Okay. Sorry. Go ahead.
Mr. Vincent, in a scenario in which WPL's natural gas utility had more gas than was needed to meet the needs of its LDC customers and Riverside, and it did not engage in a capacity release, is it the case that it would be able to do a natural gas commodity arbitrage sale to provide savings to customers?
Yes, so the arbitrage is the way that it's calculated and executed is agnostic to the transportation piece of it. It's actually tied more to the commodity itself at the supply source, which in this case would be, for example, or a example, the Chicago market, where what we're able to do because of the LNG facility, the arbitrage opportunity is able to be pursued because we can sell the gas in Chicago. This is gas that we purchased ahead of time, capturing that acute volatility in the market, which is typically corresponds with these type of extreme weather events. Capturing that volatility, capturing the margin from what we bought versus what we sold in the midst of the chaos. At that point, if we are later awarded or asked to dispatch by MISO, which is the Mid-Continent Independent System Operator, we would be able to do so because the LNG would be on site and that gas supply would be there and available. In addition, that same logic applies for the gas utility, the LDC, and that we would be able to monetize forward purchases. And then to the extent that those purchases would have been needed and delivered to the LDC, we would be able to still operate by using the LNG as the primary source of supply for the decatherms that were sold at the market.
Mr. Vincent, for a capacity release, is it correct that the time periods for the release typically correspond with seasons?
It is. It's typically seasons or annually.
And is it the case for a natural gas commodity sale that it could be a more limited period of time?
It is. It's typically limited to the what's referred to as the spot or cash market. That would be the day ahead gas market or the intraday gas market. And so really short term in nature, capturing the value on that acute volatility that really manifests in the near term market.
And then is it the case that a capacity release, the maximum amount of money that WPL could obtain through a capacity release is the tariff rate that it's paying for that contract?
That's correct. My understanding, and I don't have the exact specifics of where it is in the regulations, but my understanding is that you cannot release capacity at a value higher than the max tariff rate that is published and approved by FERC.
And for a natural gas commodity arbitrage sale, is it the case that if market conditions warrant it, WPL could receive more compensation at a rate higher than the tariff rate?
Absolutely. It's not, it is at that point would be decoupled from the capacity that would normally be used to deliver the gas from the market to either to the LDC or to the generation.
And Mr. Vincent, is it correct that the savings that would accompany doing a capacity release would flow to WPL's customers?
It would. That's my understanding.
And is it your understanding that the savings or revenue that would flow from doing a natural gas commodity arbitrage sale would flow to WPL's customers under the PGAC?
Absolutely.
And just to summarize then, for Mr. Kirschling's question about how if there was a circumstance in which WPL had more natural gas than it needed to meet the needs of its LDC in Riverside, is it correct that WPL could use either a capacity release or a natural gas commodity sale to provide savings to customers?
Yes, or both.
Your Honor, with that, that concludes the direct. So then I would ask Mr. Vincent, is it correct that in this case you filed direct testimony, rebuttal testimony, supplemental rebuttal testimony, and accompanying exhibits, which amounted to 21 exhibits, but then now reflective of the changes for a couple of those exhibits that the judge and I discussed? Is it correct that you caused to be filed those materials in this case?
That's correct.
And along with the statements that you made today, is the information in your testimony and exhibits true and correct to the best of your knowledge?
It is.
And then with that, Your Honor, Mr. Vincent's available for cross-examination.
All right. So we have questions starting with Cub
No questions. Thank you.
and commission staff.
No questions, Your Honor.
Okay. All right. So I did have a clarifying question for the witness. So the witness did describe capacity release versus the market arbitrage techniques in order to dispose of gas that the utility may not be using or expecting to use. And I was just curious in terms of the nature of releasing capacity versus and the cost savings in that bucket versus the use of the capacity release arbitrage mechanism that you described. In terms of the cost savings, correct me if you agree, let me know, but it's to me, I think the release of capacity would be an amount that would be set and determined by the contract in terms of what costs were involved to reserve that capacity. That would be the amount of money returned to the utility that would flow through customers. Is that correct?
That's correct. I believe it would be by avoided cost. So if we had
Okay.
released a capacity contract, it would be one less contract that customers would be paying for.
And that would be a known cost established in the contract.
That's correct. It would depend on which of the contracts were released. There is a little nuance there in that you would typically release max tariff rate contracts. If you were to release a discounted or negotiated rate contract, you would lose that negotiated discounted rate. So we typically focus on those max tariff rate contracts. And again, just for everyone's guidance, max tariff rate is the standard. Think of it as the published tariff rate. In order to get a negotiated or discounted rate contract, you typically
I'm sorry, I'm sorry, you broke up for me. In order to get a negotiated
or discounted rate contract, you would need to demonstrate that there's a competitive situation where you could use another pipeline or way to deliver the gas other than the pipeline.
Okay. And then in contrast with releasing capacity on the contract, the second scenario that you described basically are an arbitrage sale at a hub. That's the amount of money that's received in savings or amount of money that's made on that sale depends on the market and on the day. Is that accurate description?
That's correct, Your Honor. It's that's where where you normally see the most volatility.
Mm-hmm.
If we've seen prices as high as approaching or over $100 in Chicago during Winter Storm Uri, potentially maybe as high as 200. I'd have to confirm that, but I do know that, for example, in the Ventura Trading Hub, which is another trading hub that we use.
Let me stop you. We don't need to get into all the details there,
Sure.
But But
So, yes,
and then in
talking
terms
about-
of and I'm sorry, in terms of the amount of, I mean, I guess the amount of gas that Wisconsin Powerlight has for an arbitrage sale, that's something that the commission would need to review in a gas supply plan. Does that make sense that if there's extra capacity, extra gas contracted, that amount is something that the commission's going to need to review in a gas supply plan process. Is that your understanding?
It is not, Your Honor.
Okay.
So
How does that
with the
work?
yeah, so my understanding is that with the capacity contracts, that would be something that would be discussed in the gas supply plan and covered through that process.
Mhm.
With the arbitrage, it's more of a intraday, next day decision based on the gas need at the time. And if the gas is not needed in that intraday, which is the same day or next day, then doing what is most beneficial for customers, capturing the value of that extreme move in the market. And still, because we're capturing that value, we're able to capture that value really because we then have on-site gas supply in the form of liquefied natural gas.
Mhm. Yeah, but I guess the overall gas supply scenario would have to be set by the commission in order to have the gas available for our arbitrage. There's got to be a connection with the supply that the utility is planning for versus what might be available for arbitrage. Does that make sense?
So the amount that would be available for arbitrage is the way that I understand it would be based on what the remaining inventory is of liquefied natural gas.
All right. So, but is there a limit to the amount of gas that the company could have available for arbitrage? Is there a limit to that in any way?
Well, the limit would be, let me think about that. So my understanding is the limit would be if you were 100% hedged. So in other words, let's say, for example, say that we had every single decatherm purchase that we needed for the upcoming winter. That would be, say, through contracts, purchased at Chicago or purchased somewhere else and delivered to the gas utility, WPL LDC. And while we were 100% hedged, also held 2 BCF of liquefied natural gas, which would also be additional supply. In that scenario, it could, would be a extreme, hard to contemplate being in that position because we do not purchase forward that amount of supply. We're limited in how much we can purchase on a forward basis in our risk management programs, as well as just prudency and strategy of how to manage the supply for customers in a way that we're not going to purchase more gas than we need for the LDC needs.
Right. Okay. So if that's limiting the amount of gas you have on supply, the instances of arbitrage are really going to be far, it's going to be sort of a unique situation where you can use arbitrage. At least that's what the intention is in terms of a utility's use of that mechanism. Does that ring true to you?
Yes, it's a finite amount of supply, and there's the additional dimension of liquefying during the season or during the winter. So an additional layer of, if we had sold half of the LNG that we had on hand at the beginning of the season and felt it was worth additional cushion or supply, we could look to liquefy in the winter. Again, adding another dimension to that arbitrage opportunity. However, that reliquefaction or additional liquefaction to restock in the middle of the winter season would be really limited based on you would be doing it at a time of lower demand, where you'd have additional gas flowing into Wisconsin that you could liquefy, which would correspond with a lower demand, supply demand situation at the time, which would also bring with it lower costs or lower priced gas supply relative to what you would have sold during a peak day scenario or a peak demand scenario.
Right. I guess maybe the concern is really, would the utility be planning to have reserve capacity that duplicates the capacity that the LNG plant is going to provide? And then is that reserve capacity going to be then arbitraged, used as an arbitrage sale? I mean, to what level is that prudent for utility practice? I think that's possibly where these questions are, what staff's concern was trying to elucidate, but.
Okay, so I'll attempt to try to answer. I consider the capacity, the transportation, separate from the arbitrage. So that's why they are not mutually exclusive, and we could release capacity as well as sell the commodity and capture the arbitrage. You don't need the capacity contract in order to be able to sell the commodity.
Yeah. But you need access to the gas.
The access to the gas is where we're selling the gas. So we've already purchased the gas at the market. If we say we buy Chicago for the winter, on the day we would sell Chicago for that day or intraday. And then if the gas was still needed, and because at that point, once you sell it, you're no longer able to deliver it to Wisconsin because you would have missed your window, at which point you use the liquefied natural gas then to provide the gas supply to the LDC and potentially generation.
Okay, so you're talking only about spot market purchases.
Spot market sales.
But the original purchase.
Correct. The original purchase, I wouldn't, again, it's just probably a semantics. I wouldn't consider that a spot market purchase. I'd consider that a forward purchase. So something that was purchased in advance, potentially a week, a month, a day, even potentially years in advance.
Okay. So that's addition to the reserve capacity, in addition to the LNG capacity. So there's still an amount that the company thinks is needed, say like a week ahead, and then it's able to arbitrage that in a spot sale.
Yes.
Okay.
So we would, the commodity purchase, so the gas that we're buying at the market is not part of that reserve margin calculation. We do report it when we file. We report all of the existing purchases that we have on the books at the time of the gas supply plan filing. And then the balance of that gas supply plan volumes that are forecasted as needed is based on typically benchmarks or index price values for the market.
Okay. And then just, this might be something everyone else knows, but so the reserve capacity margin includes these future purchases as well as reserve capacity, and if the project is approved, the LNG capacity.
So the purchases are not part of the reserve margin calculation.
They're not.
The, what it is it's I think of it as the ability to deliver the gas to the demand, or to Wisconsin, to our LDC, or to generation. That capacity that we hold, the transportation contracts that we hold, and if we hold enough transportation to move it from the market to where our demand is. And that's what is based or used in the reserve margin calculation. The gas supply is something that in theory is something that you could still acquire intraday, next day, week, month in advance. So the purchase from the market is something that would be more depending on what price you're willing to pay at the time. The capacity, however, is you need to hold enough of that capacity to deliver when there's a situation where non-firm capacity is being curtailed. And in this case, those would be the capacity contracts that would be used in the calculation of the reserve margin and the gas supply plan.
All right. You've definitely gone over my head, so
That's-
so we'll leave it at that.
Your Honor, can I do a little redirect just to
Yes, you
clarify
may.
a couple of items?
Yeah.
So, Mr. Vincent, the judge asked you several questions sort of about gas market operations.
Mhm.
And I just want to make sure that as we explored a couple of those topics, we have clarity in the record about how it relates to statements Mr. Kirschling made. So Mr. Kirschling talked about if WPL were to retain its existing capacity contracts and build LNG, would that be excess capacity? Would it entail avoidable costs? And my question to you is, if commission staff or the commission were reviewing a gas supply plan that included the LNG, is it within commission authority at that time to require WPL to let some of that capacity go to avoid excess costs?
That's my understanding.
And Mr. Vincent, even though you're not saying in your testimony now that you plan a specific capacity release, would you propose a capacity release if it appeared that that capacity was not necessary for reliable service?
Absolutely. We pride ourselves in taking measures necessary to reduce costs for customers.
And then last question, Mr. Vincent, if there was a gas supply plan where no capacity release was ordered or required, and so then WPL had not released that capacity, but there was an opportunity to have gas that was not needed for the LDC customers or Riverside, would WPL still be able to provide savings to customers through a natural gas arbitrage commodity sale?
Yes, it would still be able to capture that value. It wouldn't require capacity contracts to do so.
No further redirect, Your Honor. I just wanted to triangulate it back to Mr. Kirschland's question.
All right, appreciate that. Okay, so that was redirect, and I can excuse you now. Thanks.
Great, thank you.
Oh, was this the witness? Hang on, just sorry about this. I did have an issue with, I don't know if this is something that staff had communicated to the applicant about. The past reserve margins in testimony were filed as confidential, and I was just wondering, I think that was witness Vincent's testimony. I was just wondering, in terms of looking at past gas supply plans, and I think in the testimony in particular was talking about the reserve margins in the that had been involved, the company had approved years in the past. what's the rationale for keeping those confidential at this point?
I
And-
believe
and that-
that's a,
Yeah. go
yeah,
ahead.
legal question. And then if we have a factual one, Mr.
Mhm.
Vincent. But from a legal perspective, I guess it's somewhat of WPL's trying to remain consistent with commission policy. So what I mean by that is, for example, commission staff witnesses also then identified how WPL compares to other utilities for reserve margin. And it would have benefited WPL's case to be able to bring in the past reserve margins of other investor-owned utilities' reserve margins. But the commission has continued to essentially, once they granted the confidentiality in a past order of filing, stay true to that. And so, Your Honor is raising an interesting question about how long it is. And it sort of gets into the broader policy of how much each of the utilities gets to have, at what point in time we each get to have access to each other's reserve margin information.
Okay, that's good enough. I just wanted to get that statement in the record. So, okay, so I see you're remaining consistent with the commission's determination on confidentiality for those filings when at the time they were filed. And at this point in the commission's practice, I believe confidential determinations remain in place essentially forever. And that doesn't preclude a public records request asking for release of that information, at which time the commission would reevaluate that decision. But as we stated today, we keep that information confidential and should remain confidential going forward. So that at least gives me an understanding of what the rationale is for that. So I appreciate it. And I think, I guess if the commission wants more information about that, it can ask. I don't think we need to do that now in connection with this case because, we do have the record as it is. And that's just my opinion. So let's just leave it with that. All right, great. Thank you very much. And I'm sorry, Witness Vincent, I didn't change your screen name, but you're excused at this point.
Thank you, Your Honor. Thanks.
All right. Do we have anyone else from the applicant? I don't think so.
No, Your Honor.
All right. So we were going to take Witness Adams from Cub. Let's do that now. All right, I see you there. So I'll swear you in, raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, and go ahead.
Thank you. Mr. Adams, can you just state your name for the record?
Jeff Adams.
And you are employed by the Citizens Utility Board?
I am.
All right. Mr. Adams, did you submit direct, supplemental, and surrebuttal testimony in this proceeding along with one exhibit?
Yes, I did.
And is your written testimony and the information in your exhibit truthful and accurate to the best of your knowledge?
Yes, it is.
If I asked you the same questions that appear in your testimony today, would your answers be the same?
Yes, they would.
No further questions. Mr. Adams is available for cross.
All right. Did we have any questions now?
None from the applicant, Your Honor.
Okay. Nothing from staff. All right. Thanks. You're excused.
Thank you, Your Honor.
And let's see. We'll go off the record now. How much do you think in time it'll take for commission staff witnesses?
Your Honor, I plan to ask witness Kirschling to just confirm his understanding of some of the testimony we heard earlier. But beyond that, I believe this will be quite fast.
Okay. All right. Well, let's continue and we'll see how long it actually takes. So, all right. So we'll go ahead and call your witnesses.
Thank you, Your Honor. The commission calls witness Justin Adams to the stand.
I'm here. Hopefully you me.
Yep, that's you. We got the right Adams. All right. So raise your right hand. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
I do.
Go ahead.
Thank you. Witness Adams, did you prepare and file or cause to be filed direct testimony in this docket?
I did.
Are the statements and representations in the testimony you filed true and correct to the best of your knowledge?
They are.
Do you have any additions or modifications to your testimony at this time?
I do not.
The witness is open for cross.
Any questions?
None from the applicant.
Nothing from Cub. All right. Thanks very much. You're excused.
Thank you.
Your Honor, the commission calls Rachel Waliardo to the stand.
See you there. All right. Raise your right hand. And do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
I do.
Okay. Go ahead.
Witness Waliardo, did you prepare and file or cause to be filed direct, surrebuttal, and one exhibit in this docket?
That's correct.
Are the statements and representations in your testimony and the exhibits you filed in this case true and correct to the best of your knowledge?
Yes.
Do you have any additions or modifications to your testimony or exhibits at this time?
Not at this time.
The witness is open for cross.
Any questions?
WPL does have one short question.
Okay.
Witness Qualiardo, are you able to hear me okay?
Yes, I am.
Okay. So in your testimony, you discussed how some of the other gas utilities compared size-wise to WPL when witness Hilberry was identifying the reserve margins of other utilities. Do you generally recall that testimony in your surrebuttal?
Yes, can you refer to a certain page?
Yes, I believe it was Gualiardo, page 2 of surrebuttal. Let me check. Yes, there it is on the screen. Give you a moment to review. And then, as I indicated to the judge just a moment ago, WPL is not able to access the reserve margins of other investor-owned utilities in Wisconsin because they're subject to confidentiality. And I know that then you can't provide that information. So I'm just going to attempt a question to try and contextualize, which is, in your experience working on gas supply plans, is it fair to say that the other investor-owned natural gas utilities reserve margins are generally in keeping with the 5% target?
My direct testimony answers this question on both page, I want to say 4 and 6. You go to page 4. My direct testimony addresses right there, yep, right around line 12 and 13, how the commission has a general target reserve margin of 5%. And then on page 6 of my direct testimony, I state in my direct testimony here that the commission has both approved reserve margins higher and lower than that 5% target.
Thank you for that. And I guess my follow-up question is, for the other investor-owned utilities, natural gas reserve margins, is it fair to say that their currently approved plans, well, I guess this is hard because of the confidentiality around it, so I'm doing my best here. I'm open to feedback on it. So is it the case that for the other investor-owned utilities, some of them have gas supply plans with reserve margin above 5%?
Can you repeat your question?
Let's read
Yes.
it back.
So, yeah. Oh, you want to read it back?
Yeah.
So is it the case that for other investor-owned utilities, some of them have gas supply plans with reserve margin above 5%?
Correct. So as my testimony states, there can be 5% is that target. And then the commission has approved reserve margins slightly higher and lower as stated on the screen here testimony.
And I understand that as a general characterization of practice. For the current gas supply plans in place, do some investor-owned utilities' current reserve margins exceed 5%?
I'm not sure how to answer this because we're talking about other IOU gas supply plans and the redacted reserve margin amount. So my answer off the top of my head might not be accurate with what the general response is that you're looking for. I would say that in general, they would be around, could it get, again, back to that testimony that it could be slightly above or below that 5% target.
I think I'll leave it here, Your Honor.
All right, that's fine.
Thank you, witness Beloit.
Any questions from Cub? No? And redirect?
None, Your Honor.
All right. Thanks, you're excused.
The commission calls witness Alex Kirschling to the stand.
Yeah.
Oh, can you hear me?
Yes.
Yes. Do you have your camera on?
I can see him, Your Honor.
Okay, hang on. There we go. Excellent. All right, see you there. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
All right, go ahead.
Witness Kirschling, did you prepare and file or cause to be filed direct surrebuttal and one exhibit in this docket?
Yes, I did.
Are the statements and representations in the testimony and exhibits you filed in this case true and correct to the best of your knowledge at the time they were filed?
Yes.
Do you have any additions or modifications to your testimony or exhibits at this time?
I do not.
And I just had a couple quick questions, Your Honor, regarding some of the other testimony we've heard today.
Okay, go ahead.
Your Honor, would you pull up surrebuttal Kirschling 2? Might make it faster.
Sure.
Alex, did you hear the testimony of WPL witness Curtis here today?
Yes, I did.
Do his statements answer the question you raised about the applicant's citing process for containment takes within surrebuttal PSE Kirschling 2?
Yes, that addressed the comments that I had.
Thank you. And did you also hear the testimony of witness Vincent here today?
Yes, I did.
Did his statements on capacity release answer the question you raised in surrebuttal PSE Kirschling 2?
Yes, that addressed the comments I raised.
And one last question, Judge Newmark, if you could go to surrebuttal Kirschling 4. As I believe witness Vincent was asked about this, but lines 7 through 10, there was some confusion about whether data request response AJK 7.10, whether those contracts were in the record. Given that at the time of your surrebuttal that hadn't been analyzed, is that still the case? Have you found those contracts?
Correct. That's no longer the case. Upon further examination, I was able to note that those were included in the response.
Thank you. That is all I had, Judge. The witness is open for cross.
All right, great. Any questions for the witness?
No, Your Honor.
Nothing? All right. Thanks very much. You're excused.
The commission calls witness David Minke to the stand.
Yes.
Oops. All right. I'm just going to pin you here. There we go. All right. I'll swear you in. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
All right. Go ahead.
Witness Minke, did you prepare and file or cause to be filed direct testimony in this docket?
I did.
And are the statements and representations in the testimony you filed in this case true and correct to the best of your knowledge?
They are.
Do you have any additions or modifications to your testimony at this time?
I do not.
The witness is open for cross.
Any questions?
Nope.
All right. Thanks very much. You're excused.
Thank you.
The commission calls witness Jeree Rodermacher to the stand. I can see her, Judge, if you're having trouble.
No, I got it.
can see me.
There we go. You can see you? Okay.
I
good.
can see me.
That's not so easy. All right. So, yeah, there you go. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
Yes, I do.
Okay. Go ahead.
Witness Rodermacher, did you prepare and file or cause to be filed direct testimony in this docket?
Yes, I did.
And are the statements and representations in your testimony true and correct to the best of your knowledge?
Yes, they are.
Do you have any additions or modifications to your testimony at this time?
No, I do not.
The witness is open for cross.
Any questions?
No, thank you, Your Honor.
All right. You're nothing else? Okay. Thanks. You're excused.
Thank you.
The commission calls witness Stacy Rowe to the stand.
There we go. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
I do.
All right.
Witness Rowe, did you prepare and file or cause to be filed direct testimony in this docket?
Yes, I did.
Are the statements and representations in the testimony you filed in this case true and correct to the best of your knowledge?
Yes, they are.
Do you have any additions or modifications to your testimony at this time?
No, I do not.
The witness is open for cross.
Any questions?
None from WPL.
None from Cub.
All right. Thanks. You're excused.
Thank you.
The commission calls witness Scott Schneider to the stand.
Gotcha. All right. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
I do.
All right. Go ahead.
Witness Schneider, did you prepare and file or cause to be filed direct testimony, surrebuttal testimony, one exhibit, and the XPSC DRR exhibit in this docket?
Yes.
Are the statements and representations in the testimony and exhibits you filed in this case true and correct to the best of your knowledge?
They are.
Do you have any additions or modifications to your testimony or exhibits at this time?
I do not.
The witness is open for cross.
Any questions? No? All right. Thanks very much. You're excused.
The commission calls witness Tyler Tomaszewski to the stand.
I see you there. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
I do.
Okay. Go ahead.
Did you prepare and file or cause to be filed direct testimony and exhibit PSCEA in this docket?
Yes, I did.
Are the statements and representations in the testimony and exhibit you filed in this case true and correct to the best of your knowledge?
Yes.
Do you have any additions or modifications to your testimony or exhibits at this time?
No, I do not.
The witness is open for cross.
Any questions?
None from WPL.
All right. Hearing nothing else. All right. Thanks very much. You're excused. Okay. So looks like we have all our witnesses. Is that right? we'll just be expecting a few to file by affidavit. No, I don't know why I marked them green. I'll have to change that so I keep track. And we do have the directions for refiling, and the post hearing schedule is already set. So let me just make it clear for people watching. Let's go off the record for a second. There we go. Okay, yeah, so on the record, so I just wanted to make sure we know that we'll be holding the public hearing session tomorrow and at 2 p.m. and 6 p.m. at Blackhawk Technical College. Again, like I said before, we'll start at 2. We'll take the people, whoever's in attendance who wants to make a comment. We'll go until we've exhausted that group of people, and then we'll pick it up again at 6 p.m. and do the same. I think we have the room until 9, but I don't expect to go that long. But we will adjourn once we've had provided everyone in attendance an opportunity to comment. So it may be sooner than 9 when we stop. We're also accepting written comments, so that'll be Monday, March 23rd is the deadline for that. And the way to file those is on our notice of hearing. I also wanted to mention, as part of the public session, there won't be a presentation about what the project is. There won't be a debate about the project. We're here. We will appear. Commission staff will be there to receive comments from the public. So I'd advise people to review the documents that are on file in the case, and I can show the link for all the documents in the case are located on the Commission's electronic filing system and can be observed using this link that I'm showing here on the screen share. We'll also have the applicant, representatives of the applicant, and representatives of Commission staff in attendance. So if there are specific questions the public wishes to ask, they can do so individually, sort of offline before the hearing starts, or potentially we could go into recess and have people get their questions answered. And then we'll take those comments once those questions are answered. We'll take those comments after a recess. But there's, just so people have the right expectations, there's no question and answer session, no presentation of the project, as a whole, as part of the hearing activities. I don't know what else to talk about now, so I think we're done. There might have been something outstanding, but I can't remember at this point. So I believe we'll leave it at that. So is there anything else I've forgotten we need to address before we adjourn? Anybody?
If there is, I forgot it too.
Yeah. It's been kind of a whirlwind. Okay, so at this point, let's adjourn. Take care, everyone, and we'll see some of you on Thursday.